Because again, we can't let them hesitate either. I mean, one of the first things that you can do as a brigade judge advocate or what have you is have your soldiers be so concerned about violating the law that they hesitate. And as we all know, in a combat situation, if you hesitate even 1 second, you're going to get a bullet in the head.
Welcome to NSL Unscripted, a national security law podcast, brought to you by the National Security Law Department at the U.S. Army's The Judge Advocate General's Legal Center and School. We bring you conversations and hot topics from NSL practitioners today and hope you enjoy this episode. Welcome to NSL Unscripted. I'm Lieutenant Colonel Dan Maurer, professor in the National Security Law Department here at the Army's JAG School, where I primarily teach and write about war crimes, human rights law, and command responsibility. It's my pleasure and privilege to talk today with one of the most accomplished practitioners and scholars of international criminal law and the law of war, Professor David Crane. Professor Crane's resume is long, intimidating, but ultimately quite inspiring. He was the founding chief prosecutor of the International War Crimes Tribunal for West Africa, called the Special Court for Sierra Leone. He was the first American since Justice Robert Jackson and Telford Taylor at Nuremberg in 1945 to be the chief prosecutor of an International War Crimes Tribunal. He's also a retired member of the Senior Executive Service of the United States and a retired Army Lieutenant Colonel Judge Advocate, drafter of the Department of Defense's Law of War program, and a retired professor at Syracuse. He founded the Global Accountability Network, which includes the Syrian Accountability Project, the Yemeni Accountability Project, the Venezuelan Accountability Project, the Uyghur Accountability Project, and the Ukrainian Accountability Project. He's also the founder of the Impunity Watch News at Syracuse University's College of Law. Recently published a book about his time in Sierra Leone titled Every Living Thing, Facing Down Terrorists, Warlords, and Thugs in West Africa, A Story of Justice. He is currently a distinguished scholar in residence at the Syracuse University College of Law and an adjunct professor with the Washington College of Law of American University, where he teaches international criminal practice. Most importantly, for the context of our conversation, Professor Crane is assisting in the creation of a special tribunal for Ukraine for the crime of aggression. Professor Crane, welcome to NSL Unscripted.
Well, it's a pleasure to be here and to talk with you today.
Yes, sir. So, given the ICC's recent issuance of the arrest warrant for Putin, what are your thoughts on the crime that was alleged? Did you see that one coming? It was allegations of war crimes, specifically deportation and transportation of civilians, children specifically. Was that one of the crimes that you initially focused on?
Well, again, it's interesting. One is, I think it's really important that your listeners understand that for the second time in the modern era, a sitting head of state has been indicted for international crimes. That is a huge marker placing and putting on notice to all tyrants and thugs around the world that if you commit international crimes, you will be held accountable. That notice was certainly stenciled when we took down President Charles Taylor of Liberia, first sitting head of state, but now we have the second. So that's really critical. This is a great moment in history. And so we have the president of the Russian Federation, an indicted war criminal. Now, to answer your question specifically, prosecutors, international prosecutors, look at the situation, look at what needs to be done. And my friend Kareem Khan, who is the chief prosecutor at the International Criminal Court, made an important decision, realizing that to ensure that the world appreciates the gravity of the crimes that are being committed by the Russian Federation, he needed to send an important political signal as well as a legal signal to the world that this cannot stand. The indictment of President Putin and his assistant related to child affairs is just the beginning of a further amended indictment of President Putin for other crimes, as well as his senior commanders throughout the region committing war crimes and crimes against humanity as well. So I wasn't surprised as to the technique. What he wanted to do, I think, was start building the cornerstone. And it really helped me and our work in creating the Special Tribunal for Ukraine and the crime of aggression, because we've set this thing completely up. It is a package ready to go. We have a UN resolution. We draft UN resolution. We have a statute which the UN and the Ukraine can bilaterally enter into. We even have a step-by-step guide. There's 6 steps of starting the tribunal, going all the way to the indictment of Putin and his senior political and military commanders for aggression. So the package is put together, but the challenge is, and this is, I think, important also for your listeners, the bright red thread of modern international criminal law is politics with a small p. We can create tribunals and courts, but the decision to create them and to maintain them is a political decision by the international community. And so what we're doing now is slowly but surely to include the United States, which was kind of a reluctant partner on the aggression issue up until just last month, where they publicly declared that he has to be held accountable for the crime of aggression. It is getting nations, members of the General Assembly, to step forward and back us in the General Assembly resolution giving the Secretary General the authority to, in fact, enter into that bilateral agreement. We need 2/3 of the members of the General Assembly to actually do that. So we're getting there. Indications are that we're slowly but surely getting there, but that's where we stand right now related to that. But again, at the end of the day, the indictment of Vladimir Putin for war crimes, crimes against humanity, regardless of what that crime is a significant historical event.
Right. So it sends, as you said, a political message, a signal about the gravity of what has been done to date and the willingness of the international community to kind of stand up and say, no, there was a line, you've crossed it, and we are willing, notwithstanding your military capacity or capabilities, that we're willing to say you've done this illegal act or many illegal acts. So I think there's value there. Do you think at the end of the day, justice for senior civilian leaders in the Russian government will occur through this tribunal, or will it occur through others? So domestic Ukrainian courts. What's more likely?
Well, again, there's several scenarios. Right now, it's not absolutely locked and certain that we'll have an international United Nations-backed special tribunal for Ukraine and the crime of aggression. There are 3 approaches that the international community is considering. The international approach that I have been putting together with my colleagues is the one that President Zelensky has publicly said, this is what Ukrainians want. So that helps a great deal. But there is also other models that are being considered. The United States tends to favor an aggression tribunal that is more of a hybrid, working with the Ukrainians themselves. And then there is another less popular, but one that still is there to be considered, and that is the European model of that is a European-centric tribunal dealing with the aggression. So there's those 3 models that are being considered as far as dealing with that aggression.
What's the most likely venue for justice long term for maybe even just beyond Putin, the rest of the senior civilian leadership within the government that's responsible for these crimes and atrocities? Is it going to be this special tribunal? Is it going to be a Ukrainian domestic court? Is it going to be this hybrid European model? Practical realities given, what do you think is likely to happen?
Well, having outlined the various considerations that we're thinking about related to aggression, the Ukrainian, regional, or a domestic, regional, or an international approach, the senior leadership, both in the political leadership within the Russian Federation, to include Vladimir Putin, as well as the senior military commanders, will have to be dealt with at the international level at a UN-backed international tribunal. The Prosecutor General for Ukraine has been working very hard and has been working hard since day one related to prosecuting lower-level individuals, junior officers, and individual Russian soldiers for violating the laws of armed conflict. And that's happening as we speak. And they have over, oh my goodness, they're approaching
75,000.
Yeah, at least. I've even heard this morning he was being interviewed. It's 80,000, but he's working very hard in accountability. In fact, we've already had Russian soldiers being held accountable and convicted under Ukrainian domestic law.
Right.
So the actual senior membership and leaders, and I think it's really important, again, for your listeners to understand, is everybody just talks about Putin, but we're going after the foreign minister, Lavrov. We're going after the head of their national security division. We're going after the Minister of Defense and the senior commander in Ukraine, and individuals throughout the Russian government, holding them accountable for that aggression. We have a list, and in fact, that Russian war crimes white paper that we put out by the Global Accountability Network, which I founded, the third edition, has an updated most responsible parties. These are the individuals that we're going to be looking at to prosecute. So it's not just Putin,
right,
but it's also everyone. And so this is going to be, over time, a long-term determined effort by holding them all accountable. And I think as a footnote, within the statute that we've created, there's also another crime called aiding and abetting aggression. It's never been done before. We also have other nation states who are actively involved in supporting Russian efforts in Ukraine. Belarus comes to immediate mind. But we're also looking at Iran and North Korea. Again, to send a signal to any of these strongmen around the world, and there are about a dozen, a few of which are actually actively involved in holding them accountable for the aggression in Ukraine by Russia, by supporting them and using it as an aiding and abetting.
So it's almost as if, and I'm not sure to the extent to which you're familiar with the term lawfare, but it's often used in a pejorative sense to label things, for example, that China is doing in the South China Sea, using their interpretation of the law to effectuate their own national security objectives and foreign policy, kind of twisting, if you will, due process and the rule of law understandings of other nations to get what they want, short of going to war. And it sounds like legal strategy, this prosecutorial strategy of who we indict, when we indict them, in order to send these political or diplomatic signals, is a kind of lawfare as well. Would you agree with that?
Well, I agree with the idea that we can use the law for political purposes, not being influenced by politics, but using it in a political sense. Having been a international chief prosecutor, when I was putting together my prosecutorial strategy, the things that I considered wasn't just the law. I had to consider the political and diplomatic ramifications of what I was about to do, to include potentially taking down a head of state and his henchmen. But also I had to consider both the practical aspects of how to do that, as well as the political ramifications of it, but then also the law. But one of the things that I learned I thought was very important and has never been done before, and that is considering the cultural approach to prosecution at the international level. I'm famous for the term is the justice we seek, the justice they want. In other words, you have to consider, because all of this, and again, when we create international tribunals and courts, we have to, and I was always reminding my great people in my office that we're here only for the victims. This is for and about the victims. And so if we don't respect the victims' perspectives on what is a just result, then we are not completely bringing justice to victims of atrocity crimes. So it's really critical, is the justice we seek, the justice they want. And so I've been also inserting in, as we develop our strategic plan related to the aggression court, is also doing the very same thing, and that is making sure that we don't forget who we're really doing this for, and that is the citizens of Ukraine.
So that makes me think of victor's justice in some sense. So to what extent do you see Ukrainian courts, prosecutors, trying some of the more lower level military officials? As you mentioned earlier, sir, there are 75 to 80,000 open investigations right now into all these kinds of war crimes and atrocities on the ground. By my count, 26 or 27 convictions already, but most of these are for relatively low-level soldiers. I think the first successful conviction was for a sergeant. Is that the right strategy to take in this kind of opening salvo of domestic prosecution? So this is part one of the question. Did they open up the prosecution the right way, charging the right people at the right time? And the second question is, are Ukrainian courts the right venue to try Ukrainians accused of potential war crimes or atrocities?
I have no quibble with the prosecutor general prosecuting individuals who violate Ukrainian law on their soil. And so if we have Russian soldiers who aggressively and illegally invaded his country, he has the absolute right under the Ukrainian Constitution and the Ukrainian Criminal Code to prosecute anyone who commits those crimes. again, that doesn't hamper an international effort at all. It just allows that prosecutor general. I think it's important to send a signal to the Russian people as well that we're taking care of business here. This is and sending a signal that your soldiers, your sons, and perhaps daughters are committing violations of Ukrainian law by just stepping into our soil, and if they don't follow the prescripts of the laws of armed conflict, the Geneva Conventions, what have you, then we're going to hold them accountable. So I think that is, really critical as far as doing that. So no, it's not a grand strategy. It's a strategy by someone who has an absolute right to do that, and he needs to send, on behalf of President Zelensky, a signal that we're going to deal with this under law. I think this is so important. One of the things that I've been I always advocate is the rule of law is more powerful than the rule of the gun. Even though the Ukrainian military have very effectively stopped and are pushing back Russian Federation soldiers, there's nothing. That's important, but also to show to the world that Ukraine is using the rule of law to right wrongs as well. Now, as to your second question is,
should Ukrainian domestic courts try their own Ukrainian citizens for allegations of war crimes?
Well, as our listeners, our more sophisticated listeners understand, is that signatories to the precept of the laws of armed conflict, international humanitarian law, is that in fact we encourage states parties to prosecute their own armed forces or anybody else committing violations of the laws of armed conflict on their soil using their domestic law. That is the preferred option. It's only when they're unable or unwilling to that we can, in fact, refer it to another jurisdictional body. And so, yes, I think that's they're doing what the international humanitarian laws of armed conflict require, is to prosecute their soldiers, and they're doing that as well. Now, of course, as by way of footnote, the Russian Federation has come up with these sham, quote, war crimes courts, kind of tit for tat. Ukrainians are prosecuting their soldiers, so they capture some POWs, trump up some charges, and prosecute them for the same thing. It's been my understanding is that these allegations by the Russian Federation's forces on Ukrainian armed forces personnel are really pretty much trumped up. But I've had discussions with senior members of the Ukrainian bar. They get it. They understand their obligations to try everyone who violates the law, and they're doing it with their own citizens as well.
And they're doing it in the middle of an armed conflict, middle of an international armed conflict of largest scale since probably World War II. The conflict has not ended yet, and they're still under attack, and yet they're still having courts, they're still having investigations, they're still doing what they would normally do on an everyday basis. And yet we have what seems to be this unprecedented amount of international support from NGOs, from other nations that are not parties to the conflict, that are providing investigative resources, experts on the ground. Are you aware of any precedent for that, where at this scale, at this point of a conflict, where we've seen something like that?
Well, one is it's important to understand that the world came together to face down the aggression by Russian Federation. Democracies stood up, NGOs stood up, bar associations from around the world stood up to support the Ukrainians. That's a tremendous signal as far as doing just that, going after these individuals. The challenge we have is, and it is it's not unprecedented. The thing that I would find it similar to is during Syria, we had a very similar kind of coming together for a while of the world working on. I was very much involved in that. I'm the co-author of the world famous Caesar report, which found direct evidence that Assad is killing his own people in detention facilities, and that's another story. But we had unprecedented support early on with that regard. So, it's important what's going on. The challenge, though, is, from a practical point of view, taking it from an old international prosecutor, is that NGOs and a lot of other organizations don't have the professional background to investigate an atrocity. And so they're stepping all over the crime scene. Those individuals who are charged at the domestic, perhaps regional, but certainly at the international level, will be coming in and going, oh my goodness, they've really screwed up some of the evidence. That's a real challenge. We have to be very, very careful when we have these international efforts. And I write a lot of op-eds on all of this from my practical experience in Sierra Leone, warning that we have to be careful because we do have lots of well-meaning NGOs and other organizations coming in, even countries coming in to do something to help because it looks good. But in reality, they truly are stepping all over the crime scene, obtaining evidence that could be used at the international level, domestic level, perhaps at the regional level.
So many of our listeners are going to be either current brigade judge advocate attorneys advising colonels of combat units, or perhaps operational law attorneys at a division or corps headquarters staff. And one of the major themes of our instruction here at the JAG School over the last year or so has been trying to prepare our lawyers and commanders for operating in what we call large-scale armed conflict, the kind of conflict that's occurring in Ukraine right now, as opposed to, in contrast to 20 years of counterterrorism and counterinsurgency. And if we were to deploy in that context, if the U.S. were to get involved in a large-scale armed conflict, whether it's in Eastern Europe or not, what advice would you have for those tactical level JAs, judge advocates, when they're going to go into a theater where it's very likely that they're going to come across scenes or allegations of war crimes and atrocities, either committed by locals, by the enemy, or by U.S. forces? What should those JAs do in the planning process, for example, to help prepare their commands for that event?
Yeah, I really do see in the future, we've been fighting these dirty little wars for a couple of decades where at least one party is not even following the laws of armed conflict. And yet, as we all know, that doesn't make any difference. The United States, NATO, its allies always follow the laws of armed conflict. Not following the laws of armed conflict is not an excuse. So I think it's really, really critical for brigade judge advocates, operational law attorneys, is to make the idea of bringing the law on a battlefield, particularly an intense battlefield like a large-scale battlefield, keep it very, very simple, very, very direct, so that they could, these 18 and 19-year-olds who are scared to death, who are confronting a very vigorous, determined enemy in a large-scale conflict, large conflict, to keep it very, very simple as far as how they approach the laws of armed conflict. I was a brigade judge advocate in the 82nd Airborne Division between 1980 and 1984, peacekeeping efforts and stuff like that, but Grenada, all of this stuff. I can remember standing in Green Ramp, giving these very frightened, as we're boarding C-141s, they're looking at you with their eyes as silver dollars, and you have to be very, very careful in what you tell them to do. And, I kept it very simple. I said, when you hit the ground, don't shoot at civilians. Make sure you understand your target. If you do that, you're going to be on your way. I said, we don't know exactly how the Cubans are going to react to our insertion. And so all plans go up in smoke when the enemy fires the first shot.
Right.
So make sure that you engage using what I've told you, ladies and gentlemen, mainly gentlemen, is just have a militarily necessary reason to pull that trigger. Identify your target, know that he is a hostile, and engage in that. I said, if you can just do that for me, because we're going here in about 2 hours, just do that, and then we will catch up and figure out what the battlefield is presenting us to us. So bottom line, keep it very simple. Give them 2, 3, 4 things that they could keep in their mind as they're jumping out of an airplane or air landing or hitting the beach, or what have you is just immediate things, because when those rounds are coming at them, almost as with the intensity of a D-Day type invasion, they're not thinking about the law, they're thinking about living. But again, once they get settled in and are engaged in a way that's a little bit more manageable, give them just some real simple 3 or 4 things to remember. And again, that depends on the unit, whether it be a special operations unit, an armor unit, mechanized unit, whatever the may be, a battalion landing team, what have you, is just know your unit and give them the things that they need to do so that they don't unwittingly get themselves into a potential law of armed conflict violation. But they're not going to be thinking about LOAC when they deploy in a particularly an intense, high-intensity environment. So don't get complicated on them.
Yeah.
Just keep it simple.
I wonder, though, after the rounds have stopped flying and the mortar rounds have stopped landing, they're going to encounter or could encounter situations like the Ukrainian troops have found themselves in today or recently, where they're engaging with civilians on the ground and the civilians are reporting these terrible things have happened to them. And they're reporting to that 18 or 19-year-old soldier. What is that soldier to do with that information? Do you see a greater role, perhaps, in the planning stages for kind of an integrated effort between the JAG and the civil affairs officer and the provost marshal? You're going to have these specialties at the higher echelons of command. And instead of just worrying about POW and detainee treatment, now these other officers are engaged in communicating with locals about some of the most horrendous things these locals have ever seen in their life. The tremendous psychological impact, let alone the physical impact of these crimes is just devastating, as you well know. How can JAGs help prepare their commands for that kind of that immediate post-tactical engagement where they're going to perhaps come across these crime scenes, if, for lack of a better phrase?
Well, you're going to have to use your chain of command. We can't have these young 18, 19-year-old PFCs doing anything other than noticing and reporting. Mm-hmm. So I would even keep it as notice and report up the chain of command. And somewhere within the chain of command, at probably the battalion level at first, and then in the brigade area, that is, these reportings are collated, and then evaluations are made and sent forward to obviously division or brigade task force or whatever the issue may be. Our soldiers, sailors, airmen, Marines, have to understand that they have to abide by the laws of armed conflict. Yes, they have to be respectful to civilians. My concern is we have to be very, very careful getting too much involved in any kind of atrocity situation other than being respectful and reporting, respectful to the civilians. Mm-hmm. They are victims. They are panicked. Yes, that may be a 18-year-old from Peoria, Illinois, and the first good guy that these people see is that PFC from Peoria, Illinois, and they're going to start coming at him and reporting all kinds of things. And his best bet is to give it to his squad leader, and then to just note it, note location, name, forward up. And it can be easily done by some type of simple reporting format that can go up. And fortunately, we have the technology now to take pictures, to get the grid coordinates, all of the things that are necessary. Particularly, I think what they're going to end up doing is stumbling on things like mass graves, civilians lined up, shot in the back of the head, those kind of things. Photograph and report up the situation. Yeah. Because again, we can't let them hesitate either. I mean, one of the first things that you can do as a brigade judge advocate or what have you is have your soldiers be so concerned about violating the law that they hesitate. And as we all know, in a combat situation, if you hesitate even 1 second, you're going to get a bullet in the head. So that you don't want your client, your soldiers that you are advising hesitating. You want them to attack vigorously with the knowledge that they are that they have the law on their side and to move forward to accomplish the mission. Hesitation would be a very, very difficult thing for them to do. In other words, they are so much with the law in their head that they're not engaging the enemy in accomplishing their mission. And that would also include potential running across atrocities. Note, report, and keep moving.
Yeah. That actually brings up a whole other UCMJ criminal law concern with soldiers and the proliferation of social media and their cell phones. If they have them while they're deployed and they're taking these photographs, where are they sending these photographs? Who are they submitting them to? Are they posting them online? All of these raise other ethical and criminal issues for commands to have to worry about too, where we didn't have to worry about that in the past.
Well, they're witnesses now. Mm-hmm. The pictures they're taking are now evidence or potential evidence, et cetera, et cetera. So it has to be in a way that we don't put the burden on the soldier. We put the burden on the professionals who can assess, analyze, and make decisions and advise commanders. We don't have our privates down there becoming investigators. Just keep it simple, note and report, and keep moving. Would be my perspective.
Sure. So I have one more question for you, sir. If you were leading the International Tribunal prosecuting Putin and others, would you charge him with the crimes committed by his military subordinates under a theory of command responsibility?
Absolutely. I did that with President Charles Taylor, who happened to be the commander-in-chief of the Liberian Army. Mm-hmm. And by constitution, Vladimir Putin is the commander-in-chief of Russian armed forces. He is ultimately responsible, as if he's individually criminally responsible for every single act by his armed forces in and around Ukraine. And so it's been successfully applied, and he is command responsible for what he is doing or what is going on in the Ukraine. And so I would have no hesitation prosecuting for war crimes related to the conduct of his soldiers, because he is technically in the chain of command, and he is commander-in-chief. Now, on the aggression side of the house, that will be helpful in showing that he is responsible for directing his forces to invade Ukraine. So even command responsibility in the crime of aggression is also very, very critical. He is the head of the armed forces. He directed the armed forces to invade. That is an act of aggression. It's interesting. Aggression is not that hard to prove.
Right.
It's never actually, as an act of aggression in modern era, ever actually been charged and prosecuted. However, as you go through the elements and as you think through the facts that are presented to you, proving an act of aggression by Putin and his commanders for aggression and aiding and abetting aggression is not a difficult crime to bring into court and to show. Command responsibility is also an adjunct to that and would help bolster the theory that he is the man that directed it, because he is the commander-in-chief of the Russian armed forces.
Well, sir, that brings us full circle back to the very beginning. Thank you so much for taking your time to enlighten us and to share your experience and your wisdom. So thank you so much. Listeners, thank you. This is an amazing opportunity to hear from one of the greats. We will try to post the work that you've done, that you've written, the Caesar Report, for example, on the show notes for our listeners to have access to as well. Thank you, and thank you for listening to NSL Unscripted.
This episode of NSL Unscripted was brought to you by the National Security Law Department at the U.S. Army's The Judge Advocate General's Legal Center and School. The views presented are those of the speakers and do not necessarily represent the views of the Department of Defense or its components, the Department of the Army, or the Judge Advocate General's Legal Center and School. Our department also produces the Operational Law Handbook, accessible online. We hope you have enjoyed this episode and look forward to future episodes for NSL practitioners. Thank you.